There's a lot on 502, Julie. Our next slide talks about that, breaks the rule down into different sections, and I don't know whether you'd like to talk about that or you'd like me to.
I'll talk briefly about it, and I'd certainly love to hear your input. You mentioned the legislative history of the revisions to Federal Rule of Evidence 502, which is an interesting legislative history and some very colorful case law that goes along with that. But for time's sake, I want to call our attention particularly to why the rule was enacted, which was in part to address the conflict among many of the courts regarding the effect of inadvertent disclosures of information that were protected either by attorney-client privilege or work product immunity. Three sections that I find particularly of interest to us in our conversation today of Rule 502 would be subsection B, which discusses or looks at whether or not inadvertent disclosure of privileged or protected information when it's made in a federal proceeding or to a federal office or agency, whether it operates as a waiver in a federal or state proceeding, which the rule specifically says it does not. But it discusses reasonable steps. And Ron, I'd like your thoughts on what reasonable steps are. Do we have case law that's interpreted that yet?
Well, yes, we have a plethora of case law, and I wish I could tell you that there's uniformity, Julie. But what's really happened to decide whether a party has been reasonable in avoiding waiver, and this is Rule 502B, this is the inadvertent waiver part of the rule. The rule says you need to take reasonable steps to avoid inadvertent production, and the courts have really engrafted pre-existing law into this. So I think there's some degree of uniformity, but I don't think there's a degree of uniformity that people wanted when this was enacted by Congress.
And I'll move on to subsection D and E, and I'd like to just mention the Sedona Conference resolution in regards to 502. Subsection D is entitled Controlling Effect of a Court Order, and what that subsection does is provide that a federal court may order that the privilege or protection is not waived by disclosure, which is interesting because then we look at subsection E entitled Controlling Effect of a Party Agreement, which in that subsection provides that an agreement on the effect of disclosure in a federal proceeding is binding only on the parties to the agreement unless it is incorporated into a court order. We've seen case law that incorporates it into a court order, and what we're seeing is that there became such differences between states in how this was actually viewed that the Sedona Conference set forth a resolution, and it specifically addresses privileged non-waiver orders that are entered by state courts. The resolution is interesting. It goes through and speaks to a number of different provisions of Rule 502, but what the resolution is, or what it proffers, is that to avoid any conflicts between the laws of the states and the United States with regard to the consequences of production of privileged information pursuant to a court order, the Sedona Conference promulgates a uniform law or court rule that will bind state courts. They see this as a matter of interstate comity, and it's something that I think will be addressed in the near future, hopefully not only by resolution, but also by an introduction of a new version or some other provision added to 502. What are your thoughts on that, Ron?
Well, the first thing I would comment on to you is if you're a party in federal litigation, you could have an agreement under 502E which provides there's no waiver between you, but it doesn't protect you from waiver arguments made by someone else because you're exchanging something. So I would suggest that if you're ever involved in a situation as a litigant, you always want a 502D order. I don't know what the downside of it is if you're going to be exchanging information and you want to try to cut down on cost through a quick peek or a clawback. What Sedona did, Julie, is suggest actually to the National Conference of Uniform State Law Commissioners that there be a model rule or statute adopted that states could look at to try to adopt the equivalent of Rule 502 at the state level. The big problem is that a state can't bind another state when it enters into one of these orders or a court enters into the order. And what it's suggesting is, for example, New Jersey adopts a state rule that says if Maryland has a non-waiver order from a court, New Jersey will recognize that. There's a lot going on here. I know Alabama is actively considering an equivalent of Rule 502. Rule 502 equivalents have been adopted by several other jurisdictions now, and it's really a question of relationships between federal and state courts and among state courts. There's a lot here, which again we could spend about an hour talking about.
No, that's a good definition or explanation of interstate comedy, so that's wonderful. Let's talk a little bit about minimizing risks. Where do you see education and contractual clarity playing into this?
Well, let's touch on contractual clarity first. And those of you who are ARMA members who might be listening, ARMA, I hope, is going to be coming out very soon with a little set of best practices on cloud computing that I worked on. But leave that aside. There are a lot of things you would ask. For example, you want to know where the data resides. If you're contracting with someone in the cloud and it's personal information, you don't want to find out the information being hosted in England or Germany, because if it's there, you might be subject to the European Privacy Directive. Control's another issue, because remember, if you're involved in litigation, you may be asked to produce information. The information may be out there somewhere. You want to know in a contract between you and that cloud party who has control over data. And last, an issue I think you need to raise and think about is the contract allow you to have routine access to information that's being hosted by someone else. If you don't, you may think you're saving all these economies by going out in the cloud. And the fact of the matter is, to get the data for litigation purposes or internal purposes, you may wind up spending all the money you think you saved. Education,
great point.
Yeah,
and on that,
obviously, yeah.
We had a question that came in, so I wanted to, as we're just about out of time, I wanted to address a couple of questions from our audience. One question that came in is there a blog or listserv that you recommend concerning European privacy law and U.S. litigation? And this was sent in from one of our attendees.
The Sedona Conference has a working group number 6 that deals with European data. It's got a working group number 7 that deals with Canadian information. You'd have to look to the website to see what you could have access to and the like, but there are certainly papers that are there. The Federal Trade Commission has something called a safe harbor, and the idea there is you could be certified by the Federal Trade Commission to have data brought to the United States to process. The Federal Trade Commission has information on it. I would send you to the European Commission website, and you can find information there under the European Privacy Directive. There's also an organization out of England that is called Trilantic, and Trilantic has a very good website that sets forth the rules of the European Commission, as well as statutes that have enacted privacy law, the laws of different countries in the European Union that have enacted privacy laws. So there's a lot out there, Julie.
Great. Ron, I think we're about out of time. I wanted to thank you for your time today and thank our audience. I think this has been a fantastic webinar. We hope that everyone has enjoyed joining our webinar and that you enjoyed the conversation and found it helpful. We will be sharing a replay of the event and the promised written materials. You'll soon see an email from us, that's Scarab, with information, and it will be posted to www.consultscarab.com. If you have any questions, please feel free to email us at info@consultscarab.com, and we will get back in touch. Ron, thanks again, and have a great afternoon.
Thank you, and I'm sorry we painted with such a broad brush, but there was obviously a lot here, and we're performing the education function, Julie.
Absolutely.
By telling people that there are issues.
Thanks again. Bye-bye.
So thank you very much. Goodbye.